Welcome to another session of CL4 Corporate Law. Now, during the two previous lectures, I have been discussing various fundamental areas that are involved in the law relating to corporate sector. And you are now already know how the law on company law, corporate law, apply in Sri Lanka, as well as the basic elements of a company and how the law applies to those elements. Today, I am going to touch upon another very important area, which is called the veil of incorporation. As you already know, and I have been explaining, that a corporate entity is a separate, distinct legal personality having its own legal means of personality, different from the natural persons who are involved in the company, either as shareholders, who are the virtual owners of a company, or as directors, who are said to be the agents of a company handling the day-to-day affairs. Now, covering all these natural people lay what you call the veil that covers the entire set of natural people in the company. And this particular veil is the outer cover that signify the legal personality or the juridical person represented by the company. So therefore, discussing about the veil of incorporation and how this veil of incorporation operates is very important. And today, I am going to discuss about that. Now, as you can see in the presentation, corporate law requires that a corporation be treated as its own entity, as you know, separate from the shareholders and directors. Shareholders and directors are shielded, like I said, covered from personal liability. Like I mentioned to you on the previous occasion, the natural persons do not have to bear liability. If it's a limited liability company, the shareholders' liability is limited by the shares, and even the activities of the directors are protected from any liability, as long as the shareholders and directors are working within the constitution of the company and the company law. However, if the shareholders and directors, or shareholders or directors, commits any act of privity, or what we call personal act, that goes beyond their ambit of operating within the company, then they are said to commit an act of ultravirus. How can this act of ultravirus occur? One way is that if the shareholders or directors act in lack of authority, then it falls within the meaning of acts of ultravirus. Secondly, if the shareholders or directors act in abuse of their authority, that also falls within the ambit of ultravirus. Thirdly, if the shareholders or directors act in excess of their authority, that also falls within the ambit of ultravirus. Therefore, when the directors or shareholders act in either of the three ways that lead to commit an act of ultravirus, then it is said to act or said to have acted in their personal liability rather than letting the company to absorb the liability towards that corporate body. As long as the directors or shareholders are acting within their scope of authority, whatever the consequences that the company may incur fall within the corporate liability, so that the company is liable. However, if the shareholders or directors act in ultravirus or out of the scope of authority, then in that case, whatever the company suffer will not be taken as a liability by the company. So it becomes a personal liability on the shareholders or directors so acted. Now, separating these two, where the members, either shareholders or directors, act within their authority and outside authority, is the corporate veil. Corporate veil is there to protect these natural people, the members of the company, as long as they act within their scope of authority. The moment they act outside their scope of authority, especially in act of ultravirus, then this particular veil, like a curtain, can be lifted, or this particular veil can be pierced to find out who are inside the company and catch the culprits and make them personally liable. Actually, when the members of a company are accused of committing acts of ultravirus, the court will not always lift the corporate veil. The court is in fact very careful in lifting the corporate veil because of the protectionism that the corporate veil provides towards the members of the company. It is in extreme circumstance that the court, on a complaint that there have been acts of ultravirus committed by the members of a company, the court will lift or pierce the corporate veil. The doctrine of ultravirus assures the creditors and the shareholders of the company that the funds of the company will be utilized only for the purpose specified in the memorandum of the company, or rather the articles of the company, or what we call commonly the constitution of the company. So the directors who are working in the company have to work within the powers vested upon them by the constitution or the articles of association. In this manner, investors of the company can get assured that their money will not be utilized for a purpose which is not specified at the time of investment, so that the investor's investment is very much protected and their investment will not be misused. If the assets of the company are wrongfully applied, then it may result into the insolvency of the company, that the company will bankrupt, which in turn means that the creditors of the company will not be paid, because the company's assets, it could be liquid, it could be property, immovable property, would be wasted because of the acts of ultravirus committed by the directors. This doctrine helps to prevent such kind of situation. This doctrine draws a clear line beyond which the directors of the company are not authorized to act. If it puts a check on the activities of the directors and prevent them from departing from the objectives of the company. So this is a kind of a protection that mainly the shareholders and the creditors have in the company, that their investment will be secured and will not lead to a disaster due to acts of ultravirus committed by the directors. And the doctrine of ultravirus will prevent the company to be secured and to prevent the directors from acting so. An ultravirus act is entirely different from an illegal act, because there may be sometimes acts which are really not illegal but out of scope. The directors may have acted in a manner that they are not permitted to act. It does not mean that they have acted illegally, but they have acted without proper authority. Not every act of ultravirus will lead to an illegal act, and therefore these two have to be separated. Anything which is beyond the objectives of the company as specified in the memorandum of the company or articles or constitution is ultravirus. However, anything which is an offence or draws civil liability or is prohibited by law is illegal. So there can be sometimes situations where acts of ultravirus become illegal, but not all acts of ultravirus will be considered as illegal. However, the commission of an act of ultravirus will ultimately impose liability upon the director or the directors who act in that manner. Anything which is ultra-virus may or may not be illegal, as I mentioned, but both of such acts are void ab initio. That means that not all the acts of ultra-virus will fall within the category of illegal acts, but however, all ultra-virus acts committed will end up being null and void right from the beginning that they are executed. Now, for example, say that a director has released a certain payment which he is not competent or capable of releasing within the company's business affairs under the constitution or the articles. Suppose that he has already released, that particular act becomes null and void from the beginning, so that the director will have to personally reimburse that money back to the company coffers. As far as the company's constitution is concerned, the internal and external scope and area of company's operation, along with its objectives, powers and scope, are all described there. That of course you know that a company has to be managed, administered as per its articles of association, what we call the constitution. So, the moment that a director bypass such direction provided by the constitution of the company, he is said to act in ultra-virus. A company is authorized to do only that much which is within the scope of powers provided to it by the constitution. A company can also do anything which is incidental to the main objectives provided by the constitution. So, we should not look at this doctrine as a kind of a sheer restriction where a director cannot move his hands or wings. There are certain transactions that may still be considered intra-virus or within the scope, even though the constitution has not specifically mentioned that. It is where that commission of such an act may either be approvable or can even be ratified by the shareholders after commission of the act. So, in these such circumstances, there is some air that the director can breathe, that he or she would not be very strictly restricted to a certain boundary, but at their convenience they may do so. However, doing so should be for the benefit and the interest of the company. If that is so, there is a possibility of approving such acts. Approval can also be sought by way of ratification, where such directors' acts could later on be ratified by the shareholders. And even though such act may have surpassed the intra-virus boundary and gone into some kind of a act of ultra-virus, it still can be brought in back within the intra-virus acts by way of such ratification. So one has to look at this area very carefully before putting the blame on the director, whether the director's act was indeed a sheer bypassing of the constitution that violates the interest and benefits of the company. Otherwise, if it is to the extent that the shareholders can duly ratify, such acts may fall back within the permitted parameters. Now with that, I would like you to refer to a very important and landmark case in the United Kingdom history of company law, which is called the Ashbury Railway Carriage and Iron Company Limited versus Richer. Now let's look at the facts. The Ashbury Railway Carriage Company and versus Richer entered into a contract where the company, the Ashbury Railway Company, agreed to finance construction of a railway line. Now, according to the constitution of the Ashbury Railway Carriage Company, what the Ashbury Railway Carriage Company could do is to make or build railways, commission railways, or even to appoint subcontractors and get the subcontractors to construct the railways, and that was their main business as per the constitution of the company. There was no provision in the company constitution that the company could give loans or financial facilities to anybody. Now in this matter, what happened was that the directors of the Ashbury Railway Carriage Company had approved a loan facility or finance facility to Richer. Later on, Richer, when asked to pay back, refused to settle the debt. So, when the other directors got to know that there is a contract entered between the Ashbury Railway Carriage Company and Richer, enabling the company to give a loan facility or financial facility to Richer, the directors repudiated the contract on the ground it's been ultra-virus of the company memorandum or the constitution. The directors cancel the contract. Richer filed a suit demanding damages from the company. Because otherwise, Richer will have to pay whatever he has borrowed. According to Richer, the words general contracts in the objects clause of the company meant any kind of contract. Thus, according to Rishi, the company had all the powers and authority to enter and perform such kind of contracts. So, Rishi maintained the fact that the company was eligible to enter into any kind of contract with him, and the contract of lending money was valid. Later, the majority of the shareholders of the company ratified the contract. They ratified the directors' contract. However, the directors of the company still refused to perform the contract, as according to them, the act was ultravirus and the shareholders of the company cannot ratify any act of ultravirus. And it was decided by the court that Ashbury Railway Carriage Company did not have the capacity to enter into contracts of financing someone. The shareholders rejected to ratify that contract, and the court held that yes, the shareholders can reject to ratify because the company was not permitted by its constitution to enter into such a contract that was not within the main business areas of the company. Because I told you that the main business areas of the company was to make railways. And the court pronounced that the contract entered between the company and Rishi is not valid, and those who entered into the contract as directors of the company are personally liable towards the company, towards the settlement of the money it has given to Rishi. And as you see, with an act of ultravirus on the part of the directors, in such circumstance, resulted in directors becoming liable towards the company, and directors had to finally settle from their own money the loss caused to the company by entering into such a contract. Basic principles relating to the doctrine of ultravirus include: shareholders cannot ratify an ultravirus transaction or act even if they wish to do so. Likewise, we saw in the Ashbury Railway Carriage Company case. Secondly, where one party has entirely performed his part of the contract, where the contract has been entered by way of an act of ultravirus, then reliance on the defense of the act of ultravirus was usually precluded in the doctrine of estoppel. That means those who entered into the contract with the contract cannot later on say that either they didn't know that it was an act of ultravirus, because they are stopped from relying upon such defense. Thirdly, where both parties to the contract have entirely performed the contract, then it cannot be attacked on the basis of this doctrine, because the contract is discharged, finalized. So, you cannot anyway rely upon the act of ultravirus because both parties have been settled upon the discharge of the contract. Fourthly, any of the parties can raise the defense of ultravirus. If the contract is taking place, the company, knowing that some directors have acted in ultravirus, thereafter can say that this contract has been entered by act of ultravirus and therefore it has to adjourn or it has to stop. On the other side, even the other party to the contract can deny performance on the basis of act of ultravirus committed by the company. Then if a contract has been partially performed by the performance was insufficient to bring the doctrine of estoppel into the action, then a suit can be brought for the recovery of the benefits conferred by one party to the other. That is, if the contract is still going on. Then if an agent of the corporation commits any default or tort within his scope of employment, the company cannot defend that employee from its consequences by saying that the act was ultravirus, because it is a personal act of those who commit such a act of ultravirus. However, there are trivial exceptions to this doctrine. Exceptions in the sense that whenever act of ultravirus is committed, there are ways or exceptions where such acts of ultravirus could be brought back to be proper and right, or what we call putting it to intravirus, as I mentioned before. Like any act which is done irregularly, but otherwise it is intravirus, the company can be validated by the shareholders of the company by giving their consent, like I mentioned before. Whatever the certain act that has been committed by the directors or whoever in the management, thus amount to ultravirus, can be corrected by obtaining the consent of the shareholders to the extent that the shareholders can agree to. However, we have to make sure there that if such an act of ultravirus has been committed in gross violation of the company's constitution, then even the shareholders cannot correct that act by consent, because it is the company's interest that is very important and not of the shareholders, because company is a person apart from the members. Then any act which is outside the authority of the directors of the company, but otherwise it is intravirus, the company can be ratified by the shareholders of the company. If the company acquires property in manner which is ultravirus of the contract, the right of the company over such property will still be secured for the benefit of the company. Any incidental or consequential effect of ultravirus act will not be invalid unless the company's act expressly prohibits it. If any act is deemed to be within the authority of the company's act, then they will not be considered as ultravirus, even if they are not expressly stated in the memorandum or constitution. Articles of association can be altered with retrospective effect to validate an act which is ultravirus of articles, kind of ratification. But to the extent that these acts are not gross violation of the company's constitution, as well as such acts have not brought a real damage or loss to the interests and benefits of the company. In Shuttleworth versus Cox Brothers and Company, Maidenhead Limited and others, it's also an English case where it was held that if a contract is subject to statutory powers of alteration contained in the articles, and such alteration is made in good faith and for the benefit of the company, then it will be not be considered as a breach of the contract and will be valid. In Jahangiri R. Modi versus Shangi Lada, this is an Indian case, the Bombay High Court stated that a shareholder can maintain an action against the directors to compel them to restore to the company the funds of the company that have by them been employed in transactions that have no authority to enter into without making the company a party to the suit. So that action is where the shareholders representing the interest of the company sue the particular directors who have committed acts of ultravirus, and in such proceeding you don't need to drag the company into the case, but the shareholders need to show that this is for the benefit and the interest of the company that they want to secure and retain the losses that the company has incurred. I mean, to take back the good for the company from the personal liability of the directors. What the losses caused by the directors to be brought back to the company. In determining those who are really behind such acts, the courts can lift or pierce the corporate veil, as I mentioned earlier. Should such act of ultravirus occur, the law allows for a court to pierce the corporate veil of shareholder protection and allowing for creditors to obtain judgments against the personal assets of the shareholders who have failed to make the directors responsible for this and have failed to obtain that loss from the directors back to the company. In case the directors have acted in such a way, they also become personally liable to their acts committed by themselves out of scope. In the case of Prest versus Petrodel, a UK case, this remains an exceptional remedy. As I mentioned to you, the court will not always frequently lift a corporate veil. A party seeking the lifting of the corporate veil must bring in a prima facie case, or case that can be proved on the face of it, that have very, very sufficient and strong grounds to satisfy the court in letting the court lift or pierce the corporate veil. So they have to be very, very strict and stringent grounds that could satisfy the court to lift or pierce the corporate veil. Otherwise, the court will not always as a matter of scrutiny or checking, we lift the corporate veil, because it is fundamental rule in company law that a court would not interfere or intervene with the internal management of a company. So the court is quite reluctant to lift the corporate veil to all and sundry claims that come to court. One need to fully exhaust the circumstances that the directors or shareholders have acted in Ultravirus, and that has caused tremendous losses to the company or its creditors, that would then allow the court to provide the possibility of lifting the corporate veil, and then to identify who are the real actors behind the scene, who are responsible for such acts. So, in this case, in the case of Solomon versus Solomon and Company Limited, as we have done that, the Court of Appeal agreed and also considered that Mr. Solomon using the company as a device to defraud creditors. The House of Lords, however, did not consider that there was any fraud committed by Solomon, and held that the company was a separate legal person from Mr. Solomon, and that he was not therefore liable for the company's debt. Now suppose that the losses incurred by Solomon and company was mainly due to the acts of Solomon in person, and clear evidence were produced to that effect. Obviously, the court would have lifted the corporate veil. In contrast, Solomon's case did not bring in evidence that Solomon was really defrauding the company. It was due to loss of business. Maybe he did not get good business due to competitors coming up. So finally his business ran into bankruptcy. But the fact that he was a secured creditor did not disallow him from relying upon the remaining assets. As Lord's Sumption said in pressed case, the separate personality and property of a company is sometimes described as a fiction. And in a sense it is, because we can just think of this veil, but we can't touch it. It is only a concept that prevails. So it's a kind of a fiction, but however it prevails. But the fiction is the whole foundation of English company and insolvency law, that a company is shielded by a corporate veil that protects the natural people inside the company from liability at times of where such members are really not personally liable for what the company has suffered. corporate veil is a very important area in company law. But as I mentioned to you, you need to make sure that not every time, not every action, the court will lift or pierce the corporate veil. It is in extreme circumstance where you can bring in evidence to show that a sheer gross act of ultravirus has occurred on the part of whoever the perpetrator, shareholder or director, then the court will be satisfied to lift or pierce the veil. So basically, in Sri Lanka too, the corporate veil is lifted very seldom by court. Now, let me take you all through the area of prospectors, promoters and pre-incorporation contracts. Now, before a company is to be registered and incorporated, there may be a person or persons who have the initial intention of creating this company, and they sometimes canvass among various people their idea to incorporate this company and invite those people to invest in the company. Such activities are conducted by what you call the promoters. The promoters exist only up to the time of incorporation, not thereafter. Thereafter, maybe that particular person is not there, or that particular person is a shareholder or director or whatever. But promoter is a person who promotes the idea of incorporating a company and invite others to invest. In order to do so, these promoters use what you call a prospectus. Prospectus. That is to invite people to invest in the shares of the company to be incorporated, and this prospectus will detail out many fundamental areas and aspects of this company to be formed. It will detail out the type of activities, the type of businesses, shareholding, directors, what sort of income that it is to generate, what sort of profit that it would secure, and all kinds of things. So prospectus is a formal legal document designed to provide information and full details about an investment offering for sale to the public. As per section 43 of the Companies Act, where a company allots or agrees to allot any shares in or debentures of the company with a view to offering all or any of those shares or debentures for sale to the public, any document by which the offer for sale to the public is made shall for all purposes be deemed to be a prospectus issued by the company to be. As per section 40, subsection 1, no prospectus shall be issued by or on behalf of a company or in relation to a company to be formed unless on or before the date of its publication, there has been delivered to the registrar for registration a copy of such prospectus. So, providing a copy of the prospectus to the ROC, Register of Companies, prior to any activities being conducted of the future company that is going to be formed, is not proper. Therefore, always the prospectus that is intended to invite the interest in investing in this particular company to be, needs to be submitted to the ROC. And such prospectus need to be signed by every person who is named in such prospectus as a director or proposed director of the company, or by his agent authorized in writing. Because then those who are eager to invest in the company will look at the prospectus and decide whether they would invest or not. Because every investor wishes to make profit out of their endeavor, and for that they need to be convinced by the future affairs that this company is going to execute. For that, the prospectus is a quite important document. However, in normal private companies, we don't see prospectus, because it is quite very rare that a private company being incorporated by inviting various people to invest. It is mainly in public companies that they do this. Especially, prospectus are issued at the time of a further allocation of shares, and you may have even seen in papers, newspapers, especially like the banks, they publish the prospectus inviting new shareholders and investors either to invest in shares or stocks in such bank, and that particular prospectus provide all the information necessary to arouse the interest of the investors to invest. Next, the promoter, as I mentioned earlier, as per section 41(6), promoter means a promoter who was a party to the preparation of the prospectus or of the portion thereof containing the untrue statement, but does not include any person by reason of acting in a professional capacity, like what we call the experts, for persons engaged in procuring the formation of the company. So, promoter is a person who is engaged in such a manner that he is involved in the preparation of the prospectus or portion of it, whether such statements are untrue or not, and also who promotes the idea of forming this company and invite the attention of the investors, and thereby getting the investors to invest. Now, the other important area connected with this are the pre-incorporation contracts. Now, there are two kinds of contracts in a company. That means contracts entered by the company When you say contracts entered by the company, that simply denotes contracts that are made by the company after incorporation. However, there are some times where you need to enter into contracts with some people or with some companies or with some entities for various matters even prior to incorporation. Now, just take an example. If a company to be formed need to purchase chairs and tables before the company is set up in a certain location, then the promoter who is acting for the purpose of bringing in the company to formation will have to obtain or enter into transactions in purchasing these tables and chairs, either by paying in full or on a credit basis. Whatever happens, it does not mean that the promoter is entering into such contract in his personal capacity. He himself is entering into such contracts or transactions for the benefit and interest of the company to be formed. However, since the fact that there is no company in existence at that time, what he enters into would be either on behalf of a company to be formed or in his own personal capacity, but for the company to be formed. So, therefore, prior to an incorporation of a company, there may be circumstance that one has to enter into contracts seeking later ratification or acceptance by such company when such company comes into existence upon incorporation. Now, such contracts that are entered prior to the formation of a company are called pre-incorporation contracts. So, generally pre-incorporation contracts are entered by a promoter on behalf of a company to be. So, this is a kind of a tricky situation. The questions arise whether it is the company that is to be formed that enters into the contract, or whether the promoter is really representing on behalf of the company. How can a non-existing company allows a promoter to enter into a contract? All various kinds of complications come in. In fact, the common law situation previously was that pre-incorporation contracts may not be valid because there is no company form that authorizes a promoter to enter into such transactions. But however, the later developments in the statutory law legislations have enabled the entering into, not only the entering into pre-incorporation contracts, but also providing the validity on post-company formation. Pre-incorporation contracts are those contracts purported to be made on behalf of a company entered before the incorporation of the company. These are generally brought about by the promoter who intends the formation of such company, who is thereby obliged to bring the company in the legal existence and to ensure its successful running. In order to accomplish his obligation, he may enter into some contract on behalf of prospective company. Nature of pre-incorporation contract is slightly different to ordinary contract. Nature of such contract is bilateral. It has the features of tripartite contract, because why? The promoter, company to be, and then a third party that is going to come into contract with these two, tripartite. In this type of contract, the promoter furnishes the contract with interested person, and it would be bilateral contract between the promoter and the third party. But the remarkable part of this contract is that this contract helps the prospective company who is not a party to the contract. Final benefit goes to the company. When a promoter buys the chairs and the tables and chairs will come to the company. So the final beneficiary is the company anyway, though they have been purchased prior to incorporation. As per section 23(1), the expression pre-incorporation contract means a contract purported to have been entered into by a company before its incorporation, or a contract entered into by a person on behalf of a company before and in contemplation of its incorporation, either of the situations. Under section 23(2), it states, notwithstanding anything to the contrary in any law, a pre-incorporation contract may be ratified within such period as may be specified in the contract, or if no such period is specified, within a reasonable time after the incorporation of such contract, in the name of which or on behalf of which it has been entered into. So our law in Sri Lanka provide the possibility of obtaining ratification by the company towards the pre-incorporated contract once the company comes into operation or once the company is formed. Why it says that notwithstanding anything to the contrary in any law, that is because the common law situation previously was that pre-incorporation contracts cannot be validated. But now the statutory law has filled that gap. As pre-incorporation contract that is ratified shall be valid, shall be as valid and enforceable, and if the company had been a party to the contract at the time it was entered into, and such ratification is valid when it is ratified by a company in the same manner as a contract may be entered into on behalf of a company afterwards is incorporation. That means that our law treats a pre-incorporation contract that has been ratified by a company later on is valid in the same way that particular company enters into a contract with someone after it is been formed. which means that a pre-incorporation contract is valid as any other contract that this company is going to or entered into afterwards its incorporation. In pure common law sense, pre-incorporation contract does not bind the company as held in the Kellner versus Baxter and others case. This was a very famous common law situation. As I mentioned to you previously, the common law situation was that the pre-incorporation contract does not bind the company. Now what happened there? A group of company promoters for a new hotel business entered into a contract purportedly on behalf of a company which was not yet registered to purchase wine. Once the company was registered, it ratified the contract. However, the wine was consumed before the money was paid, and the company unfortunately went into liquidation as soon as it was incorporated and before the wine seller was paid. The promoters as agents were sued by the wine seller on contract. They argued that liability under the contract had passed to the company by ratification to the company and that they were hence not personally liable. It was held by the court, however, that as the company did not exist at the time of the agreement, at the time of purchasing the wine, it would be wholly inoperative unless it was binding on the promoters personally, and a stranger cannot by subsequent ratification relieve them from responsibility. So the court there did not put that burden to the company, and the company was already bankrupt. It went into liquidation. And the company creditors refused to accept that bill for the wine as a part of the company liabilities. So the court held that the promoters were personally liable for entering into a pre-incorporation contract, even though the company had later on ratified. So this had a gap in the law. As held by Earl C.J., as there was no company in existence at the time, the agreement would be wholly inoperative unless it were held to be binding on the defendants personally. Now this is the situation that was later remedied by the statutory law by providing the security and safety for promoters who enter into various kinds of pre-incorporation contracts that are ratified by companies that are formed later. So now the statutory law situation is that the pre-incorporation certificate, pre-incorporation contracts are binding the parties as of the general other contracts of the company after formation. In Newborn versus St. Solid, Great Britain, the signature and contractual document will be a complete nullity because the company was not in existence. That was the previous common law situation. In Cockburn, C.J. in Twycross versus Grant said, you observe that a promoter is one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish the purpose. The promoters are therefore generally held personally liable for pre-incorporation contracts. If a company does not ratify or adopt a pre-incorporation contract under the Specific Relief Act, then the common law principle would be applicable and the promoter will be personally liable for breach of contract. And this position has now been altered in Sri Lanka's company law, as I showed to you before, by incorporating the statutory law that such pre-incorporation contracts are valid and the company itself is bound by the pre-incorporation contract as of the general other contracts that the company enters after formation or incorporation. Now, let us move into the area of articles of association. I have been expressing this term very much during my lectures, and I told you that the articles of association, as they are called, is primarily the constitution of the company. Now, generally in a kind of a society or organization, we have a constitution. Even a country has a constitution. But in the realm of company law or in the realm of corporates, the constitution of a company has a special name called the Articles of Association. Earlier, there was also a term called Memorandum of Articles, Memorandum of Association, which is the primary document by which the objectives of the formation of a company are expressed, and you simply register the Memorandum of Association with the Register of Companies and then follow the Articles of Association. But however, with the enactment of the new law, the number 7 of 2007 Companies Act, the requirement of submitting a Memorandum of Association was removed. So now it is only the Articles of Association that you got to submit, anticipate in the incorporation of a company. So, Articles of Association form the more primary and basic rules of that company's existence and conduct of company affairs. Now, Articles of Association is considered the primary piece of legislation of a company and its virtual constitution, as I mentioned. A company must have Articles of Association prescribing regulations for the company and registered unless it is based on the model articles. Now, there are two ways of preparing the Articles of Association of a company. One way is that you create your own Articles of Association, but attending to the main areas, especially there are lawyers and accountants who do that whenever their services are sought to form a company. So they create set of Articles of Association specifically attending to the areas and aspects that their clients request them to do in the formation of a company. And secondly, without obtaining such services of professionals, one can also simply get a copy of the Articles of Association model schedule that is there in the Companies Act and can fill in the blanks, put all your company details and submit to the Register of Companies. Now, of course, the process of registering a company has been very much simplified by the ROC, where one can simply log into the online website and register a company, and even subscribing to the model articles that the web provides in the ROC website. Whatever the way that articles of association are to be made, these articles are going to be the driving force of the vehicle of a company. I mean, basically the company is run by such articles. In a very practical manner, practical sense I should say, it is pretty much better that whoever who forms a company attends very carefully to the matters that he or she wants to put in the company constitution or the articles, because as you know, articles of association are the rules that drive the company forward. If there are any kind of obstruction that is going to happen with regard to a certain kind of businesses that you cannot do, then in that case your articles obstruct the growth of your company. Now, that is why it is important to attend to the articles of association specifically as per your requirement. However, you can amend your articles of association from time to time, but the company law requires that a special resolution is passed at a shareholders meeting, and this has to be ratified by the annual general meeting that happens only once a year, or at such special general extraordinary meeting that is convened for that purpose, and copy of such amendment need to be deposited with the ROC in order to obtain the legal validity and effectiveness of such amendments. According to section 13, the articles of association of a company may provide for any matter not inconsistent with the provisions of this act other than the first schedule hereto, and in particular may provide for the articles of association will unveil the objectives of the company, the objects of the company, for what purpose this company has been formed, the rights and obligations of shareholders of the company, which are very important because they are the real owners of the company, and the management and administration of the company, such as the way in which the directors are meant to work, act. That is also very important for the general administration and management of the company affairs. As per section 14, the articles of association set out in the first schedule hereto, also referred to as the model articles that I told you previously, that you can simply rely upon and register with the ROC, shall apply in respect of any company other than a company limited by guarantee. So, the first schedule model articles can only be relied upon to incorporate a company other than a guarantee company. For a guarantee company, it's a special set of articles that you need to have in its formation, except to the extent that the company adopts articles which exclude, modify or are inconsistent with the model articles. So that's what I said, that there are people who are very careful in the formation of a company, of their own company, and thus attend to their own articles of association rather than depending on the model articles that are more general in structure. Articles of association shall be adopted by special resolution of the company, as I mentioned to you, and where a company by special resolution alters its articles, amend, it shall give notice of such resolution to the registrar within 10 working days with new articles, if any. Within 10 working days upon such an amendment or alteration being done, you need to provide a copy of such to the registrar of companies. The articles of a company shall bind the company and its shareholders as if there were a contract between the company. So now we are coming into a new area, which means that articles of association operates as a contract. A contract between whom? A contract between the company, the artificial, juridical, legal person, and the natural people who are the shareholders. So the articles of association will operate as a contract between the company and its shareholders. Unless there are anything to the contrary where that resolution or the holding of those shares would increase the liability of the shareholders to the company, unless the shareholders agree in writing to be bound by resolution or accept the shares, as the case may be. So the articles of association will make sure that the necessary shareholding of the company are very much intact and protected, and that operates as a contract between the company and the shareholders. So articles of association binds the shareholders and company. As per section 18, a shareholder has a right at any time to request a company in writing for a copy of the articles of the company, subject to a fee if applicable, and the company shall comply with such request within 5 working days. So if there is a request by anyone, shareholder, for a set of copies of the company articles, the request has to be met within 5 working days as per the law upon the receipt of such request. In John Shaw and Sons Salford Limited versus Shaw, we have discussed this case previously as well. Peter John Percy Shaw had a company together. They had an argument over owing the company money, and the result was a settlement. Peter and John would resign as governing directors, promised they would not take part in financial affairs, and independent directors would be appointed and given control over the company's financial affairs. When the independent directors required John and Peter to pay money to the company, John and Peter refused. The independent directors resolved to bring a claim against them, even though they are shareholders, for the fact that they have refused to pay back the money what they owe to the company. the independent directors who are outsiders who came in to the company have now asked Peter and John to pay, and failing which gone to courts. The company and Percy, the only other director, contended the resolution was ineffective because Percy, John and Peter Shaw were all brothers. So Percy, along with the company, claimed that the resolution was ineffective. The Court of Appeal upheld the first instance court's decision so that the shareholders could not circumvent the company's constitution and ordered the directors to discontinue litigation and getting the shareholders of the company to comply with the company articles. Whatever they owe towards the company, they have to pay as per the company articles. So therefore, the court discontinued the litigation, however, subject to the fact that those three shareholders, Peter, John and Percy Shaw, honor the articles of association of that particular company. In Carlin versus Drury, it was decided that the court generally does not allow litigation by members where a procedure for redress is set out in the articles of association. Because whenever there is provision in the articles of association on how to run the company, how to acquire lost property, how to make someone liable in that company, the court would not interfere. Because as I told you before, it is a cardinal theory or concept that courts would not interfere with the internal management of a company unless the situations come to such a difficult position that the company cannot exist anymore with such issues. Then only the court will put its fingers. Otherwise, the court will not interfere and the court will not entertain any action that comes to court to regulate the company affairs. If the company articles of association provides remedy. Now, this is a very strong point that the company has to run with its own rules and regulations that are included in the articles of association. The Bankside Brewery was a partnership composed of 300 people that began on 21st June 1808 for a term of 99 years. Brewery was one of the three managers, and the regulations of the partnership contained a provision for managers to be removed on a vote of the annual general meeting on Lady Day, Michaelmas. In the case of alleged misbehavior, a special general meeting could be called by a committee of 12 partners who audited the accounts. The partnership could be dissolved after 2 consecutive votes of the 3/4 of all the partners, with another subsequent confirmation vote in general meeting. All these things were provided in the articles of association. It was mentioned that the plaintiff having remedy in their own hands in the articles of association itself, to which they have not resorted, desiring to be understood, not to repudiate the jurisdiction, but that it will not interfere, the court will not interfere before the parties have tried that jurisdiction that is available by its articles of association. So you go back to the company, act as per the articles of association, take the remedies as per the articles of association, But if you still fail, then come to court. Otherwise, the court will not always intervene or interfere in every type of a conduct that is said to be unacceptable, which the articles they have themselves provided. In Sitco Banking Corporation NV versus Puzzers Limited, a judicial decision of the Privy Council on appeal from the British Virgin Islands in relation to the validity of amendments to the Memorandum and Articles of Association of a company and the requirement of shareholders to exercise votes attached to their shares in the best interest of the company as a whole. Idle MR stated that the power conferred on companies to alter the regulations contained in their articles is limited only by the provisions contained in the statute language. Is the power conferred by it must, like all other powers, be exercised subject to those general principles of law and equity which are applicable to all powers conferred on majorities and enabling them to bind minorities. It must be exercised not only in the manner required by law, but also bona fide for the benefit of the company as a whole, and it must not be exceeded. These conditions are always implied and are seldom, if ever, expressed. But if they are complied with, I can discover no ground for judicially putting any other restrictions on the power conferred by the section than those contained in it. So the entire judgment of this case unveils the fact that the company affairs have to be conducted as per its articles of association. If any wrongful act been committed, then the remedies are to be taken as per the articles of association. But if such a resort fails, then you simply come to the court seeking a just and reasonable remedy from the court to protect the interests and benefits of the company. Now I am moving to company contracts. The company contracts, here what I am going to discuss, are different from that of the pre-incorporation contracts. I told you previously that there are two types of company contracts. The pre-incorporation contracts that are entered prior to the incorporation of a company. Then after the incorporation of a company enters into the general company contracts. So now let us see how to enter into company contracts. As a company is a legal person, the company can contract by its own name and style, such as ABC Private Limited. But however, as the company cannot operate like a human being, we know it's only an artificial person, its affairs should be handled by natural persons, such as the shareholders or the directors who have been appointed to conduct the managerial and administrative affairs. Therefore, as per section 19, a contract or other enforceable obligation may be entered into by a company in the following manner. An obligation which, if entered into by natural person, is required by law to be in writing, signed by that person and be notarially attested, may be entered into on behalf of the company in writing signed under the name of the company by two directors of the company. So, general company contracts need to be in writing, signed and sealed, and to be notarially executed if needed. When signing, you obtain the signature of two directors of the company. If there is only one director, if it is a one director, single director company, then you need to obtain the signature of that director. If the articles of the company so provide, by any other person or class of persons. If the articles of association provides that there is no need for a director to sign, then a director need not sign, but whoever who has been authorized by the articles of association to sign such contracts, such requirement has to be fulfilled. So, if the articles of the company so provide, by any person or class of persons, or one or more attorneys appointed by the company on behalf of the company, and be notarially executed such contracts. So, it has to be in writing, under the signature of either two directors. If there are no two directors, then one single director. If the articles of association has allowed somebody else to do it, then accordingly that person or class of persons, or the attorneys of a company who are authorized to do so, and such document needs to be notarially executed. Then an obligation which, if entered into by natural person, is required by law to be in writing and signed by that person, may be entered into on behalf of the company in writing, signed by a person acting under the company's express or implied authority. Now, apart from the first set of people, it can also be entered by person acting under the company's express or implied authority. Now, express authority in the sense that the company has expressly conferred the authority. Express can be either by words, oral, or in writing. So, in any of the way, if the company has allowed somebody to sign on behalf of that company, verbally expressed or in writing expressed, that person has the right to execute company contracts, or otherwise by implied authority. That person may be provided with implied authority, which means that the authority is not explicitly stated so, but the company has impliedly authorized him or her to enter into the contract by implication. It is not expressly stated so, but by implication, by letting that person to sign, by conduct or by implication. Thirdly, an obligation which, if entered into by natural person, is not required by law to be in writing, may be entered into on behalf of the company in writing or orally by a person acting under the company's express or implied authority. The third situation. Now, before we end today's lecture, I would like to discuss an exercise. I have taken two tasks. First one, according to the Articles of Association of D and I Limited, the object of the company is manufacturing and selling books. According to a recent survey, manufacturing of LED bulbs is a profitable other than manufacturing books. But the directors of the company are not aware of the legality of the contracts which are not authorized by the Articles of Association. and it is required to advise the directors of D&I Limited. Now, how to address this? Now, the Articles of Association of D&I Limited has specifically made proviso for manufacturing and selling books for this company. Now, the business that is more profitable, they say, is manufacturing of LED bulbs. Now, these are two different types of business activity. However, the Articles of Association allows only to produce books and selling books. Now, the directors want to go into a different area of business of manufacturing LED bulbs. In order to do so, you got to amend the articles. Otherwise, you are falling into a situation like we discussed about this Ashbury Railway Carriage Company Limited case. Because you cannot simply do activities what your Articles of Association does not allow you to do. So, the Articles of Association have to be amended. So, you need to give the advice to the directors of D&I Limited. Firstly, about the Articles of Association, what it's all about, what effects that Articles of Association has on company, and how an act of ultravirus can be committed by the directors if any other business is done violating the applicable Articles of Association. And then you simply advise the directors to amend the Articles of Association by way of a special resolution, as I mentioned, and deposit that instrument, the alterations, with the Register of Companies, the ROC, and obtain the approval so that you could proceed in, the directors could proceed in undertaking a different type of a business such as manufacturing of LED bulbs. So, that is the way you have to approach that. Task 2, the Articles of Association of ABC Private Limited set out every member is entitled to cast 1 vote per share. Ranjit, a member of the company, holds 100 shares of the company. However, at a general meeting, the chairman of the meeting refused to recognize his 100 votes. Ranjit filed an action for damages on the basis of breach of contract between himself and the company. So, first of all, we will attend to what is required, because the section B is a different area. What you are required is to advise the directors of ABC Private Limited in this matter, where Ranjit's 100 shares that gave 1 share each to Ranjit has now been curtailed by the present board, and for that Ranjit filed the action for damages. And now your advice is needed for ABC Private Limited, for the company. In addressing that, you simply have to deal with section 21 of the Companies Act. A company or guarantor of an obligation company or any person claiming under the company may not assert against the person dealing with that company with any person who has acquired rights of the company that the articles of the company have not been complied with, or the person named in the most recent notice filed under section 223 or the annual return delivered under section 131 of this act are not directors or the secretary of the company, as the case may be, or a person held out by a company as a director, officer or agent of the company has not been duly appointed, or does not have authority to exercise the powers and perform the duties that are customary in the business of the company, or are normal for a director officer or agent of a company carrying on business of the kind carried on by that company, or a document issued by any director, the secretary of the company, or by any officer, agent with actual or normal authority to issue the document is not valid or genuine, unless that person has, by virtue of that person's position with the relationship with the company, or to have knowledge to the contrary. Now, what is relevant there is that specific part, but formally you have to introduce the main area that a company's articles of association cannot be violated at any time. When the articles of association provides a vote each for each of the share, that has to be respected. The company director cannot take, or the board cannot take a decision to curtail it unless a proper alteration of the articles of association are done. Therefore, your advice will be to the company to maintain in accordance with the articles of association, and also otherwise Ranjit can take the necessary actions as per the law, as I explained. In the second section, Edmund, a lawyer, was appointed by the Articles of Association of ABC Private Limited as the company lawyer for life. After some time, Edmund was removed from the post. Edmund is going to file an action for damages on the basis of breach of contract by the company, required to address the directors of ABC again. Now you see under section 20, subject to its articles, a company may by instrument in writing executed in accordance with the provisions of section 19 appoint a person as its attorney, either generally or in relation to specified matter. Any act of attorney carried out in accordance with the instrument referred to in subsection 1 shall be binding on the company. Now suppose that the particular lawyer, attorney, has been now removed from the post where his appointment was made under the Articles of Association for life. Once the appointment is made, that appointment has given the lawyer a lifetime appointment as the company's attorney. So if a particular change has to take place, the Articles of Association again have to be altered likewise, because what the Articles of Association now say is that his appointment is for life. If it is to be altered, you need to comply with the alteration procedure of Articles of Association, as I mentioned. And in addition, under section 20, subject to the articles, a company may by instrument in writing executed in accordance with the provisions of section 19 appoint a person as its attorney, either generally or in relation to a specified matter. In any act of attorney carried out in accordance with the instrument referred to in subsection shall be binding on the company. What I am focusing here is that a person like an attorney should work trustably towards a company. So his trustworthiness is important for the company. Therefore, if he is to be removed for whatever the reasons, you got to follow the procedure altering the Articles of Association, and it does not provide indefinite appointment like the appointment that has been made here for life in case of such a person in trust However, the proper procedure has to take place. Practically, what happens is that such attorneys would require a kind of a compensation package. If he is to be voluntarily resign, but no matter what, it is for the company to remove him if the company does not desire so, subject to the fact that the proper alteration of the company articles are carried in accordance with the company law that we discuss. So, with that, I come to the end of today's lecture, and I will meet you all with the next session on CL4 corporate law. Till then, have a nice time, and thank you very much for listening.